We are handling close to 2,000 inquiries per year. We can handle approximately 90% of them with our in-house staff. And when we need to escalate for legal information, we call on our partner and general counsel, Mike Trackman, who is here with me today. And as Mike well knows, number one on the hotline is FMLA, which is the Family Medical Leave Act.
We typically try to find out if they are subject to the FMLA, if the employee is subject to the FMLA, and then we deal with structuring a program that will comply with the law, which can be daunting and really does require a lot of know-how and information.
FLSA, the Fair Labor Standards Act.
The key to the FLSA from an employment perspective is determining who's an exempt employee and who's a non-exempt employee. A very big issue right now. The federal government is really on top of this. It's who gets overtime and who doesn't. And then there's the issue with who's an employee and who's an independent contractor. The federal government just appropriated $46 million to investigate that because that too is an extremely hot issue. So we're all over that when an employer calls on that issue.
ADA, which is the Americans with Disabilities Act.
Employers frequently want to know, do I have to take the employee's word for that? Is there some way that I can check to see if the employee is telling me the truth and really does have a disability? And the answer is yes, but you have to follow certain rules. If you don't follow rules, big trouble. If you do follow rules, you can handle it.
Another topic that we are frequently asked is on policy development and employment practices liability.
Employers need to have the right kind of policies in place so that when they do something, they can refer to the policy as opposed to being accused of just making things up as they go along. So that some employees get good treatment and some employees get bad treatment. So policies are very important from that perspective.
We also get questions on pre-employment testing, such as drug testing or background checks.
There are some issues here. The ADA restricts the timing that you can utilize when you're doing pre-employment screenings. So too with criminal background checks. Certain cities like Philadelphia has some restrictions on that, although you can generally do it if you do it right. So employers want to know who they're hiring, whether they have any skeletons buried in their closets. You can investigate, but there are certain procedures that you do have to comply with.
Another hot issue on the hotline is termination issues.
What we have to determine more than anything else is whether they've got the documentation in place to show why they terminated and to show that they terminated for a lawful reason, not an unlawful reason. Oftentimes that entails setting up a documentation procedure for the company so that they can solve the problem that they've got right there and solve future problems as well with regard to other employees.
NonCompete and confidentiality agreements.
Employers want to know, how can I keep my most valuable employees, the ones who know my secret sauce, the ones who know my customer lists, how can I keep them from going to the competition? There are ways to do it. It can be difficult, particularly if you try to add it on during the course of an employment relationship as opposed to before the employment relationship began. You have to provide certain levels of consideration. There's a procedure to follow. We know how to do that. We do that all the time. Sexual
harassment and how to conduct investigations.
You need to respond to charges of sexual harassment in a specific, defined way. You need to have a complaint procedure in effect. When the complaint comes in, you need to investigate it professionally with someone who knows how to handle those complaints in a way that complies with law, keeps the confidentiality of the investigation in place, keeps documentation the right way. We do that. We also try to focus on how to prevent legal liabilities that incur from sexual harassment. That's an art form. We've got a lot of experience in that, enjoy working in that territory because it saves an awful lot of money for an awful lot of companies if you do it that way.
And finally, the aging workforce.
Companies that talk about wanting to inject young blood into the company, that sets the stage for an Age Discrimination Act violation. And you simply can't do that. You can't play fast and loose with trying to make your workforce younger. There are things that you can do. You can create retirement incentives. You can deal with it in accordance with certain prearranged strictures of the law, but you have to tread very, very lightly when you're dealing with an aging workforce.
So these are just sort of round out our top 10 most frequent topics on our hotline. If you'd like to know more about how you can take advantage of this valuable service, visit our website or call our toll-free number.